we'll just move to the table of contents that what will we cover. So this is what we are going to cover. We are going to talk about now a patent has been granted and it's moving towards the grant stage. So what are the rights which will be given to the patentee and what are the exceptions? So this is a very important thing to remember that no right is absolute. You always have exceptions which are associated with rights. So if you have rights for a patentee, then there are also certain exceptions wherein those rights won't apply. Then we talk about the term of the patent, then maintenance of a patent. So what do you mean by maintenance of a patent? So once a patent is granted, to maintain that grant factor of the patent and to ensure that it remains granted, you have to kind of pay a fees. So to kind of keep it in the patent register. Otherwise, your patent will lapse. So to kind of keep it on the patent register, you have to make sure that your renewal fees is paid on time. So that is what is called as a maintenance of a patent. Then we talk about assignment of a patent. That is when you kind of completely assign all the rights of the patent to a third party. And then sometimes a patentee might feel that they want to surrender a patent. So surrender is something which we have to cover in the next session, as in which should be like next week. But if I get time, I'll try to cover it today. Otherwise, we'll cover it next week. So surrender is something which we can cover with revocation. But if I have time, I'll try to cover it today. So let's move forward. Now, grant of a patent. Now, section 2P defines a patentee. Why am I discussing the definition of a patentee? Because in examination, in multiple choice questions, there have been times wherein there has come a question like section 2P defines and there are options. So section 2P defines a patentee, or sometimes they will ask you a patentee is defined in what section, or they will ask you the definition of a patentee, that as per the Patent Act, a patentee is. So it is important to note that patentee is defined in section 2P of the Act, and it means the person for the time being entered on the register as the grantee or proprietor of the patent. I hope we are clear on this thing that inventor is different from the owner. So there will be probably in some cases inventor and the owner of the patent or the proprietor of the patent will be same. But sometimes inventor and proprietor of the patent are not same. For example, if a person is working in a company and during his tenure with the organization, he kind of makes a product. So that the person who is the employee will be named as the inventor, but the company will be the owner of the patent. So there's a difference. We have to be clear that an inventorship necessarily does not mean that you are the owner of the patent. Sometimes in some cases, if I'm an individual inventor and I'm working on my own and I do not have any company to whom I'm employed, I'm doing everything on my own, then I will be the inventor and I will be the owner. But in certain cases, inventorship and ownership might not be the same. So I hope I'm being clear here. So, but a patentee, as per the Patent Act, is a grantee or proprietor of the patent. So let's say I am the inventor, but I have worked during my employment with ISERD. So ISERD will be named as the proprietor, but I will be the inventor. So inventorship and the grantee of the patent will not be the same. The person who is actually the owner and the person to whom the patent belongs, not necessarily a natural person, but it can be a body corporate also, that person is a grantee of a patent. So let's not confuse ownership with inventorship. They are two different concepts. Now, section 43 states that when an application for a patent has not been refused by the controller or is not found to be in contravention of provisions of the Act, the patent shall be granted expeditiously in the name of the applicant or joint applicants as the case may be. So what does this mean? That you have filed your patent application, everything has been found in order. There is no contravention of the provisions of the Act. For example, it does not contravene section 3, section 4, and it kind of satisfies all the criteria of novelty, non-obviousness, industrial applicability, section 3, section 4, section 8, then the contents of the specification are fine and everything has been done. That is when the patent will be granted. So an application has not been refused by the controller on certain grounds, or it is not in contravention of provisions. Like what can be the provisions under in which there can be a contravention? For example, section 3, section 4, secrecy directions. So it is not in contravention of any of these, then a patent is granted in the name of the applicant or joint applicant. So important thing to notice that it's not necessary that there is only one applicant. There can be joint applicants. For example, let's say IIT Madras and IIT Delhi are kind of working together on inventing something. So that way, both of them are joint applicants. So both of them will be the owners of the patent. So there can be multiple owners as well. There can be multiple applicants and multiple owners. So the date on which the patent is granted is entered in the register. The controller will publish the fact that the patent has been granted and the documents are open for public inspection. Note, it is to be noted that the date of the patent on a date on which the patent is granted is not the same as the priority date. Your priority date is the date on which everything else before the priority date becomes a prior art. Right? So the priority date, if suppose it's 1st January 2022, so anything which is in public domain before 1st January 2022 will be considered as a prior art. And basically it's your priority date which kind of counts for everything. But the date on which the patent is granted is also important, and that is something which is also entered in the register. And this is not to be confused with the priority date. So date on which the patent is granted is different from the priority date. Now, once the patent has been granted, the controller will publish this fact that the patent has been granted and documents are open for public inspection. For example, if somebody wants to see the FER, or FER is generally public even before the patent has been granted. But for example, the deposit of the biological material which has been made at the IDA, or for example, you need more information about the applicant. So all this becomes public after the grant of the patent. So this is section 43. Section 44, I have not written it here, but it's a very small section which says that in case the applicant is deceased, then in that case, controller has the power to amend the application in name of the person to whom the right would otherwise accrue. So that means if the applicant is like no longer there, then in that case, it's a deceased applicant, and then the rights will accrue and to the person to whom otherwise the other rights would go. And the controller will amend this thing and amend the applicant and give the name, write the name of the applicant as the owner. Then sections are not a very big section, a very small one, 44. Then 45 says that every patent shall be dated as the date on which the patent application was filed. So this is what I'm trying to say, that the date on which the patent is granted is entered in the register, which is different. But a patent is always dated on the date on which the application was filed. So let's say if application was filed on 1st January 2021, and the patent is granted on 1st January 2024. So the date of grant is 1st January 2024, but the patent will be dated as on the date of which the patent application was filed, that is 1st January 2021. So this is important to note. And section 46 states that patent is granted in India has effect only in Indian territory. So why section 46 is important? Because there has been a question in previous examination, and the question said that a patent that has been granted in India shall. So options were have effect in Indian territory, have effect in all over the world, have effect in Asian countries, have effect, I don't know, there were like 4 options like that. I'll probably like just go through what was the 4 options. I'll just probably read that out. Yeah, a patent awarded by the patent office is valid in all Asian countries, all countries that adhere to TRIPS, Indian territory, all of the above. So it is important to note that section 46 says that a patent granted in India will have effect only in the Indian territory. For rest of the world, it is going to be a prior art. So for example, my patent is granted in India. I cannot go and exert my patent rights in US because I have a patent in India. I do not have a patent in US. I will not be able to exert my patent rights in US. But if somebody else files an application, my patent will become a prior art. So I hope I'm clear here. And if we have any questions with respect to this slide. So I read one question that there are two joint applicants, and in case one of them is no more, who will take the ownership of the patent in place of the deceased applicants? I will be covering that. So we have assignment and transmission of patent. So I will be covering that in that part. Do we have any more questions? Or I'll just move forward to the next slide.
Ma'am, under section 45, when you say the patent application was filed, so will it be the provisional date in case when it comes through provisional route, or that date will be decided based on the complete specification?
No, so provisional application is something which is going to preserve your priority date. And within 12 months, you have to file your complete, otherwise your provisional goes to waste, right?
Yes.
So that date of filing of the provisional application is your priority date. So that is the date which you are going to consider.
Yes, sometimes sometimes there is also a rule in Indian Patent Office that if you have filed a complete specification as a provisional, and later you just have converted that provisional into final application without any amendments, then that date will be considered as the filing date, right?
Yeah, so that is under section 9. So this kind of comes as a section. I'm talking more on a very broader perspective. Like had a provisional application which was having no claims, and then you go toward the complete application, and considering no such adjustments has been done, so the provisional date is kind of your priority date.
Okay. Right? Yeah. Thanks. Understood. Thanks.
We don't have any more questions, so I'll move towards the next slide. Now we talk about
just a minute, ma'am. So in case of provisional filing, provisional date is a priority date, right? But later within 12 months, we file complete specification. So what is the date of filing of the patent considered as? Date of complete specification or date of provisional?
So your provisional specification is preserving your priority date, right? So in that case, your provisional specification will be the date of filing of patent if you have filed complete within 12 months. If you are unable to file your complete specification within 12 months, so in that case, you kind of forego the entire application.
Extensions. Okay, so in case of provisional filing followed by complete filing within 12 months, the date of provisional filing is a priority date as well as it is a date of filing of the.
Neha, I just want to say one thing, that today I am covering section 43 to 53, right? What you are asking me is kind of a question of section 9, and it's more of a, preliminary phase, or, the earlier phase of that. I'm trying to cover 43 to 53. So if we could just limit questions to what we are covering today, because I have not covered the section of provisional act for provisional specification, section 9. So I really don't know what has been done. But what I'm trying to say is that if we kind of take up questions from the previous chapters, this session is just going to go on. So if we could
no problem, ma'am. Just that it came in a flow, that's why I asked. But it's okay. We can limit it to today's session. No problem.
So let's just limit it to today's session. Otherwise, it's going to go really, really lengthy. So
no problem, ma'am. Yeah, we can proceed.
Okay. Section 47. So section 47 I have not done yet. It will come after section 48. So I have only covered 43, 44, 45, 46, and now I'm going on 48, and after 48, I'll go on 47. So section 48 of the Patent Act provides for the rights of the patentee under the Act. So here, if your patent has been granted, there will be certain rights which accrue on the patentee. Now, what are these rights? These rights, they give the patentee the exclusive right to prevent third party from the act of making, using, selling, or importing the product in India. Now, if you see, the word is in India. Why? Because a patent which is granted in India has effect only in the Indian territory, right? So if it is a product patent, then any third party will not be able to make, use, sell, or import the product in India. The catch here is without prior consent. So in case there is a licensing agreement, or the patent has been assigned, or there is some form of consent which has been given to the third party. So in that case, the third party is not infringing upon the rights of the patentee. So without prior consent is important. Otherwise, I have a patent, I license my rights to you. Now you start using or selling the invention or making the invention. Then I cannot say that you are infringing on my patent rights because you have my prior consent. It is important to note what are the four elements, what are the four acts which are basically not allowed without the consent, which is making, using, selling, or importing. So these 4 points, which is making, using, selling, or importing of the product, is not allowed without the prior consent of the patentee. And if somebody is doing that, then in that case, they are infringing upon the patent rights of the patentee. Now, this happens when the subject matter of the patent is a product. Now, what if the subject matter of the patent is a process? So in that case, the patentee has the exclusive right to prevent third parties from the act of using the process for sale or selling the product obtained directly by that process, right? So basically, you cannot use that process or use that process to make a product and so then sell that product. So the crux is that without the consent of the patentee, if you are making, using, selling, or importing the product, or you are using the process or selling the product obtained from that process, then in that case, you are infringing the patent rights if you are doing it without consent. If you have the consent, then you're not doing any infringement. So I hope we are clear here, and if we have any questions on this slide. So great, I'll move forward. Yeah, so here I'm talking about section 47 now, which is exceptions to the right of a patentee. So this is a very weird thing about the Patent Act, that exceptions are in section 47, but the rights are in 48. So if we kind of go in order, 48 should be about like if it's about rights, then rights should come first and then come the exceptions. But we are having exceptions first in section 47, and then 48 is about rights. Now, section 47 provides certain conditions where exclusive rights of a patentee are limited by certain specific acts. For example, like if one of these acts is being done, then in that case, you are not infringing on the patent rights of the patentee. First is government use. Now, what do we mean by government use? That if suppose it's a product patent or it's a process patent, then the government can use it merely for its own use. So for example, a patent has been granted, but government feels that, okay, we need this process or we need this product. Like for example, considering the scenario of COVID. Now, somebody has a patent on a very important COVID vaccine in India, and the government feels that, okay, we need it for the government use, not for, now this, there are 3 exceptions. So I don't want you to confuse government use with public health, but now they want to use it merely for the purposes of government functions. So in that case, they can do it, and it will not be an infringement of the patent right. You're not kind of stepping on the right of the patentee. So first, there are 3 major points. One is government use, one is experimental use, and third is public health. So government use says that if it's a product patent or a process patent and government is using for its own use, then it is not an infringement, or basically it's an exception to the right of the patentee that can be done. So you have those rights. You have your right that nobody can make, use, sell, or import your invention without your permission, but the government can do it for its own use. Let's move to the next slide. Second exception is experiment or research. It says that any granted product patent may be made or used, and any process in respect of which the patent is granted may be used by any purpose, by any person for the purpose merely of experiment or research, including the imparting of instructions to pupils. This ensures that there is no impediment to the right to education of individuals. So basically, a product patent may be granted or a process patent may be granted, but if it is being used only for the purposes of experiment, for example, I need an XYZ product which is patented, but I need to experiment it, or I need it as a catalyst for my experiment, or maybe I am an instructor or I'm working in a chemical lab and I want to use that chemical to demonstrate something to my students. So I can do it for experiment or research purposes. Why? Because if I cannot use it, then in that case, your patent right, the patentee's patent right, is hindering me to develop anything further. For example, yes, you have developed a product, but I cannot use it to develop something else. So that's why we have this exception wherein you can do experiment or research, including imparting of instructions to pupils. So you might need that product. Let's say you need XYZ product along with some other ingredients to form something else. You want to experiment this, whether this will give the accurate results or not. So you have to have that exception wherein you can use it freely for experimental purposes, research purposes, or teaching to the students. Next slide, please. Third is public health. Now, in case of a patent in respect of any medicine or drug, it can be imported by the government for the purpose merely of its own use or for distribution in any dispensary, hospital, or other medical institutions maintained by or on behalf of government or any other dispensary. That means that, okay, for example, I have a patent on COVID-19 vaccines, right? Now, government can actually import. Now, suppose I have a patent in India and I have the patent on, say, Covishield vaccine, right? But there is a shortage. There is a shortage of vaccines and we do not have enough vaccines for anyone. Now, what government can do? Government can import more of COVID-19 vaccines, even if I have a patent, because public health kind of takes a priority over patent rights. So this is a very good example to understand that how government can actually import a product for its own use or for public health purposes, even if you have a patent. So remember, there are three exceptions. One is the government use, that government can use the patented product or process for its own use, merely its own use, then experiment or research or imparting instructions to pupils. And third is, if it's a public health thing, then in that case, your patent rights kind of take a backseat. So if we have any questions of 47 and 48, we can take that now.
Madam, here one question, madam.
Yeah.
Madam, suppose there is a vaccine developed in US or Russia,
Okay.
and can government of India import it without saying that it is for the public health distribution, without infringing the patent in that country?
So if I understand correctly, that the vaccine is developed in US and there are no patent rights in India
Yes, yes,
of
you are
that.
right.
So if there are no patent rights in India, it kind of, for example, Pfizer has not been able to launch its vaccine in India because it is stuck on these patent issues only, right? So it kind of depends on the vaccine manufacturer or the drug manufacturer if they want to exert their patent rights in India. Then in that case, they can take a vaccine. But for example, uh, like I would like to kind of edit this example a little bit. Now, let's just say that it's an Indian vaccine, an indigenous vaccine, which is being developed in India. And it is kind of being exported to Canada, US, Russia. So government can say that, okay, you are making it, but then somebody else is also making the vaccine. You have a patent, but I'm still importing this vaccine because of the shortage of the vaccine and higher demand. So if somebody is a US based manufacturer and they have their vaccine, they might come to India, they might not come to India. They might want to come to India without patent rights or with patent rights. It kind of depends on them. Because if India is having a public health crisis, US can help only out of humanitarian basis, but they are not bound to. I'm talking about a patent which is already there in India and it has effect in the Indian territory. Then in that case, if suppose more of the product has to be imported from abroad, government can do it, considering that there is a patent in effect in India. I hope I'm making
Okay,
sense.
madam. Yeah, thank you, madam, for clarification. Yeah.
Okay, so now I'll move forward to the next slide. Now, section 49 is important. I want you to know this section because there is chance that there might be one question on this section. So either it's going to be a very straightforward multiple choice question, or it can be a subjective question wherein you have to kind of only explain section 49. So either of the cases can happen, that, okay, they might give you the crux of the section and they will ask you to pick which is the correct section, or they will give you a problem statement and the answer of the problem statement is going to be that you have to elaborate section 49, because otherwise you do not use section 49 on a daily basis, or in daily transaction of patents. We don't use section 49, but I have included it because there might be a question on section 49. So section 49 provides that patent rights are not infringed when used on foreign vessels which are temporarily or accidentally in India. So for example, I'll give you an example. For example, I have a patent on some machine part, right? And that machine part is being used as a part of an aircraft. And that aircraft comes to India accidentally, right? Now, accidentally or on temporary basis, like for some time it has come to India. Like for example, it has just made a landing, and or maybe accidentally it has arrived in India. I cannot shout that my patent rights are being infringed because that foreign vessel has come to India and one part of it uses my patent. Why? Because section 49 says that your rights will not be infringed when it is used on a foreign vessel and that foreign vessel is in India temporarily or accidentally. Okay. The use of the invention on board a vessel or aircraft registered in a foreign country or a land vehicle owned by a person ordinarily resident in such country, which comes to India, including the territorial waters, temporarily or accidentally, will not infringe the rights of a patentee. Okay. However, this will not apply to vessels, aircraft, or land vehicles owned by persons ordinarily resident in a foreign country, the laws of which do not confer corresponding rights with respect to the use of invention on vessels, aircraft, or land vehicles owned by a person ordinarily resident in India, while in ports or within territorial waters of that foreign country or otherwise within the jurisdiction of courts. So what does this mean? If the foreign vessel belongs to a country which is not giving reciprocal rights to Indian people, right? So, okay, we are saying that if a French aircraft lands in India that uses a part which has a patent in India and that vessel has come temporarily or accidentally, then in that case, it is not a violation of patent rights, but the France government is not giving the same right to the Indian people. So in that case, section 49 will not apply. So this is a little bit confusing, but if you kind of see, there is two parts. First part is that the patent right will not infringe if it is being used on a foreign vessel which is temporarily or accidentally in India. But the exception is that this section will not apply if the foreign country to which the vessel belongs does not offer reciprocal rights to Indian people. I hope I'm clear here. I'll move forward then. So section 107 and 107A, I am only covering just a little bit of 107 and 107A just to give a fair idea. Otherwise, this will come more in the chapter. Sorry. This will come more in the chapter of infringement, but I just want to give you a fair idea about what 107 and 107A is. So there's this one question which says, if the product is already in use, why it is not figuring in prior art itself before the grant of patent? So let's just say that patent is what patent rights you have. It depends upon the scope of your claim, right? So for example, my scope of the claim is that a product which is ABCD, say 4 things, right? I'm kind of covering that only. But let's say that foreign vessel, which I was talking about, uses this product, but not in the way which has been described in the claims. This all is a very subjective thing. And what you are actually seeking your protection on depends on the scope of your claims, that how broad or how narrow your claim is. So if suppose your claim is too narrow, that anybody can surpass it, and let's say they are, let's say the foreign vessel is kind of surpassing it by going left, right, and center, and it has already been granted. So in that case, it can be a very different thing. So I can probably give you one example of this section. Let me just hold on. I'll just give you one example of the section. Okay, so it says a ship named Voyager is registered in Panama and operated by White Water Lines from Brunei, accidentally entered the territorial waters of India in the Bay of Bengal. The Indian Coast Guard confiscated the ship and brought it to the Chennai port. Upon inspection, it was found that Voyager had an underwater exploration robo-aim for its actual needs. The said equipment contains many features that are claimed in a patent granted to the Indian Maritime University. IMU files an infringement case against the owners of the vessel. So what will happen? So in this case, Section 49 will apply. Why? Because that ship kind of accidentally entered the India on, it accidentally entered India in the territorial waters, and it has underwater exploration robo-aim for its actual needs. So this is also one important thing about Section 49, that the patent that we are talking about, or the patent which we are thinking might get infringed, is being used by that vessel for its actual needs. Like they are not carrying it and bringing it to India, they are using it as a part of the vessel for its own operation, right? So that is why for its actual needs is also an important component. The equipment contains many features which are claimed in a patent granted to IMU, right? So it is not that they're completely taking your patent claim. It has a lot of features, and because probably your claim was so narrow that it has kind of formed a part of the equipment. I hope you're getting what I'm trying to say with this example. Hello. Hello, am I audible?
Ma'am, can you please repeat it again?
Okay.
More elaborately.
Give the example. A ship named Voyager registered in Panama, accidentally enters Bay of Bengal, which is the territorial water of India. Now it has accidentally entered, and the Coast Guard has confiscated the ship and brought it to the Chennai port. Upon inspection, it was found that this ship Voyager has an underwater exploration robo-aim, which is using it for its actual needs. Like actual needs means that it is using it for its running and functioning of the ship. The said equipment contains many features which are claimed in a patent granted to IMU. And IMU is Indian Maritime University. So they cannot say that it is infringement. Why? Because Section 49 will apply. Because this ship has entered accidentally in India, and it has a product which it is using for its own purposes, like for the purposes of the running of the ship. And it has accidentally come to India, and it's a foreign vessel accidentally coming to India, and it has a part which it is using for actual needs, and that part has been patented in India. So in this case, Section 49 will apply, and it is not infringement as per Section 49. So how it has escaped the search of the prior art, and that's what I'm trying to explain, that sometimes what happens is that your claims are too narrow. Like what I'm trying to say is that this robo part, which I'm talking about, kind of incorporates your patent as well. So you are claiming it in such a manner that it is escaping the prior art. Your claim are kind of very, very broad. It includes certain aspects of the prior art, but the overall claim itself becomes novel. You're trying to get what I'm trying to say, that it kind of, when you do drafting sessions, you will understand this art of drafting, that sometimes certain elements of your claim can be prior art, but your whole claim can be novel. So this will be covered once you do the drafting sessions, and you will understand that why drafting of a patent claim becomes very, very critical to escape the prior art. Sometimes when we are drafting patents, we see that yes, there is a prior art which is available in this scenario, or for this product we have a prior art, but we know that there are certain features which are not available in prior art. So you have to draft in a smart manner that you can escape your prior art and see that this prior art is forming an element of the claim, but it is not the entire claim. So I'll just move forward on section 107 and 107A. I'll just take a quick break of 1 minute, if that's okay, to drink water. So just give me 1 minute and I'll just come back. Okay, so quickly going to section 107 and 107A. I will not be covering these two sections in detail because this will probably more come when we're talking about infringement and infringement proceedings. But I just want to cover a little bit of this section. So section 107 states that every ground available for revocation of a patent under section 64 is a defense for a suit of infringement, and the grounds under section 47 are also a defense against infringement. So defenses is something which we will be covering in infringement proceedings, but it is important to know that the exceptions to a patent right, which we demonstrated in section 47, are also defenses against infringement. So if I accuse you of infringing my patent rights, you can probably take a refuge under section 47. Then section 107A states that any act of making, constructing, using, selling, or importing a patented invention solely for uses reasonably related to development and submission of information required under any law for time being in force in India or in a country other than India that regulates manufacture, construction, use, sale, or import of any product shall not be considered as infringement of patent rights. Now, for example, I am using a product because I have to submit some information which is required by, let's say, Drug Controller Authority of India, DCGI. So for example, if I have to give some information to them, or let's say there is a drug control or FDA, let's say if I have to give some information to US FDA, and to give that information, I have to use that product. So in that case, this will not be infringement. So this is somewhat an experimental use or a research exception. But the catch here is that if you are using the product, or if you're making, using, constructing, selling, importing the product for submission of information that is required by law. So law asks, or let's say FDA asks you to submit some experimental data, or let's say Indian Drug Controller Authority asks you to submit some data. And in that case, you have to use that product. So in that case, you will come under section 107A. This is also called as a Bolar provision. This means that an act that would otherwise be considered an infringement may not be considered so if it is done to comply with law of any country for certain purposes, right? Also, section 107A B part says that if a patented product is being imported by a person is being imported by a person from a person who is duly authorized under the law to produce and sell or distribute the product, then also it is not an infringement of the patent rights. Right? So if you are authorized to kind of import a patented product and you are doing it, you are importing a patented product from a person who is otherwise legally authorized to sell or distribute the product, then it is not an infringement of patent rights. This is called as parallel imports. So 107A, it has two parts. 107A, which talks about BOLAR provision. That is, if you have to submit any information to comply with any law of India or any other country. So that way, you are not infringing on the patent rights because you are doing it to comply with the law. And in case you are importing a patented product from a person who is authorized to distribute or sell the product, then also it is not an infringement because that is the law of parallel imports. So I hope I'm making some sense. We will be discussing more about this when we talk about infringement. But why I wanted to cover it here is so that you know that because we are talking about exceptions, so 107A is also an exception. Like section 47 is an exception to the right of a patentee. 107A is also an exception to the right of the patentee. And section 47, section 107A, they are generally used as defenses against infringement. Okay, if we have any questions, I'll take it now or we move forward. So let's move forward. Now, rights of owners. These are very small sections and very, sometimes we kind of tend to skip these sections. They are very, very small. They're like 2-line sections, 3-line sections. But it is important to know these sections because sometimes in the examination, you will get some very tricky questions and you might not know where did I study it because they're like just 2-line sections. So that's why we are covering it now, because if it comes in the examination tomorrow, you know that, okay, yeah, this thing which we
Ma'am,
studied.
am I audible?
Yeah.
Okay, ma'am, I had one question about section 47. Ma'am, can pharmaceutical companies can also take this as a defense, like if they are using any patented product to prepare any kind of drug which is patented, so can they take this as a defense?
Which one? Which one? Experimental use or what?
Yes, experimental use or
So if you
research
are,
maybe.
yeah, yeah.
Knowing the
But if you-
components of the drug. So
yeah.
isn't it unfair to the?
No, because they are not, first of all, if a pharma company is using the product only for some experimental purposes or only to carry out further research, so it will be covered under section 47. Secondly, the pharma company is not making, using, selling, or importing the invention, right? So in section 48, we covered 4 acts, right? Making, using, selling, importing. Neither they are using, neither they are selling, neither they are making as in it's not about if we like look at in terms if we look at very literally, making would mean I'm making it, but sometimes making also means like using it for profit, right? So if it's not coming, if otherwise they are making it but they are not deriving any profit from it and they're only using it for experimental or research purpose, so they will be covered by section 47.
But they can anytime prepare that drug and sell it in some other name. Who
No,
is
they
going to
cannot.
come to know?
No, they cannot. If they start selling it or they kind of just alter it and they kind of start selling it, so in that case, it will become an infringement because now it has escaped the experimental use exception. They are only allowed to like use the product only for their internal experimental and research purposes. If they start selling it, if they kind of start alter just, a little bit of the composition, just a little bit of ratios are being altered and they start selling it, so that way they will not be covered by section 47. Then it will be an infringement.
Okay, thank you, ma'am.
Okay. So section 50 states that if a patent is granted to 2 or more people, then both are entitled to an equal undivided share in the patent. Now, for example, I have a patent along with you. We both are joint applicants and now the patent has been granted and we both are joint owners. So because we both are joint owners, we have an equal undivided share in the patent. 50% patent belongs to you, 50% belongs to me, equal undivided share. But there is a catch, that if there is an agreement which states that one of them will have higher rights as compared to other, then the agreement will overrule the section. That means we both, otherwise we both were joint applicants, now we both have joint rights, we both are co-owners of the patent under section 50. But we have an agreement which says that, okay, I kind of gave in more capital for the patent. I made all the investments, I raised all the capital, I did more work than you. So I am entitled to a higher share. And you have signed that agreement. There is an agreement which says that I am entitled to a higher right in the patent as compared to you. So in that case, section 50 will not apply. But if we do not have this agreement, then in that case, both the co-owners have equal share in the patent. So a licensing agreement or an assignment deed with respect to the patent cannot be granted by one of them without the consent of others, in case there is no agreement to contrary in this regard. So that means if you have made an agreement which says that, okay, I will have a higher share than you, maybe because I have invested in it, maybe I have given you a higher capital, maybe these are the reasons because of which I want a higher share, and we both have mutually agreed and signed on this agreement, then in that case, I will have a higher right as compared to you. But if we do not have any such agreement, then both the co-owners have equal rights in the patent. So I hope I'm clear here.
Yes, ma'am.
Moving forward. Yeah. Now, section 50, subsection 5 states that the law applicable to the ownership and devolution of movable property applies to the patents as well, till these laws do not contradict Patent Act, and nothing mentioned in section 50, subsection 1 or 50, subsection 2 applies to mutual rights or obligations of trustees or such legal representatives of a deceased person. Therefore, there can be transmission of patent rights. So remember, we discussed section 44, which said that in case it's a deceased applicant, so amendment can be done and controller can give it to the rightful person. So read it with this section. This section says that law applicable to the ownership or devolution of movable properties. For example, if somebody owns a movable property and that person is a deceased person, then the property gets transmitted to their legal heirs, right? Same thing will happen in patents. So in case a patent applicant is a deceased applicant now, so the patent rights will devolve upon their legal heirs, right? Till these laws do not contradict the Patent Act, and nothing mentioned in this section applies to mutual rights or obligations of trustees or legal representatives of a deceased person. So otherwise, if a person dies and he leaves some property behind, it goes to their legal heirs, right? So same thing will happen with patent. And section 44 says that if a person is no longer there, then the controller has the power to amend the application in the name of the rightful heirs. So I had this question early in the class that in case one of them is no more, then who will take the ownership of the patent in place of the deceased applicant? So because patent rights are transmissible and they devolve upon the legal heirs, then the legal heirs of the deceased applicant will come into picture, right? So moving forward.
Just a question, ma'am.
Yeah. Yeah.
So how will be the legal, these people will be known to the patent office? Do we have to?
So legal heirs are always named either in the will of the deceased person, or if there is no will, then you have family laws to decide who will be the legal heir. So you kind of, if we have a scenario, if we have this scenario, we do have succession acts to decide who is going to be the legal heir. Or if there is a will, then you go ask for the will. So the will says that all of my property, say, goes to my son. So in that case, son becomes the legal heir. He will have all the property, including the patents.
No, but in case of sudden,
you have other acts which
you
are
have
not,
other acts. Okay.
Yes, there are other laws which will determine it, and because these laws will be applying to all forms of property, it will also include patent, because patent is also a form of property.
Sure. Got it. Okay, thanks.
So, ma'am, do we have to update patent office whenever any death is there? Like, like any of the applicant dies
Yeah,
accidentally.
if suppose any of the applicant is no longer there, then the legal heir will have to make an application to the patent office, and under section 44, the controller has the right to amend the application if the deceased applicant is no longer there.
Okay, okay. So that legal representative has to do all these things.
Yeah. If the legal heirs are more in number, will all of them get patent rights of the deceased applicant? However, so again, the
It
proportion
depends.
of rights is not considered, is not dealt in patent law. It is more about the Succession Act. But the only factor that you need to know here is that patent rights get transmitted if the applicant is no longer alive, right? So if we kind of get into this, that how will the rights get a proportion, I'll have to kind of pick up another area of law which is not patent. So that will kind of go in Succession Act, which we are not touching, right? So the point to be noted here is that patent rights are transmissible, just like a movable property. Your patent rights can also devolve upon your legal heirs, just like any other form of property. And the controller has the power to amend the application in the name of the legal heir if the applicant is no longer with us, or if the applicant is no longer alive, right? So power of controller to give directions to co-owners. So I want you to imagine a scenario. Now imagine a scenario where Mr. X wants to sell a patent to one Mr. AB, and Mr. Y and Mr. Z, who are co-owners, they don't want to give the patent. They don't want to give the rights of the patents to Mr. AB. There is no agreement that provides more share to Mr. X as compared to others. Now, what will Mr. X do? Now, Mr. X, Mr. Y, Mr. Z, all three of them have equal rights in the patents because they do not have any agreement to the contrary, and they all have equal undivided share in the patent. But Mr. X wants to sell the patent to Mr. AB, and Mr. Y and Mr. Z don't want to. Now, what will Mr. X do? Mr. X can take recourse under section 51. Section 51 states that Mr. X can apply to controller in form 11 along with the statement setting out the facts upon which he is relying. And after, controller will consider his statement and his request, and then controller will give direction if he thinks fit. So this is left to the discretion of the controller. Mr. Y and Mr. Z are not complying with Mr. X. He can fill out form 11 and give a statement to the controller. And if controller feels that Mr. X has a case, then in that case, the controller will give a direction to Mr. Y and Mr. Z to comply. Now, if the direction is in favor of Mr. X and Mr. Y fail to comply with the directions given by the controller under section 51 within 14 days after being requested in writing to do so, then controller will give further directions to Mr. X, empowering him to do so in the name of Mr. Y and Z as well. Controller shall not dispose of any such application without hearing. So what does this mean? That Mr. X has applied to the controller to give directions to the co-owners in form 11 and a statement setting out the facts on which he relies. Now controller feels that yes, Mr. X has a strong case. Then he will ask Mr. Y and Mr. Z to comply with the directions and give directions to Mr. Y and Mr. Z. Now, even after giving directions and within 14 days, Mr. Y and Mr. Z have still not complied with the directions given by the controller. So in that case, controller also has the power to tell Mr. X that, okay, you do it in the name of Mr. Y and Z as well. But the controller has to hear both the parties. A proper hearing thing, which we did discuss in section 25, there was a proper hearing procedure that you have to give a 10-day notice and everything. If that all is done, and then controller can give a direction to Mr. X that, okay, forget Mr. Y and Mr. Z, you go ahead and do what you want. So this is important here because you might get a subjective question in a scenario like this. You might be given a scenario wherein you have to think about section 51 and answer the question, or you will be asked about which form is to be filled and you have to write form 11, or the power of the controller to give directions to co-owners is in which section. So you have to remember three things: that you might get a subjective question, which is a very lengthy one, and you have to keep in mind section 51 and explain, or you will be asked the form, or you will be asked the section, that which section talks about giving directions to co-owners. So I'll move to the next slide. I hope I was clear till here, because now we'll be moving towards the next topic, which is term of a patent. So section 50 and section 51, you have to read in consonance with each other, because section 50 talks about, just a minute, because section 50 and section 51, section 50 talks about how the patent rights are devolving and how everybody has an equal undivided share in the patent. And section 51 talks about the power of the controller to give directions to co-owners. So we have covered this both. So I will be moving to the next topic, which is section 53, term of a patent. Yeah. So I'm talking about term of a patent. So the term of a patent is 20 years from the date of filing of the application. Again, date of filing and not the date of recordal of patent in the register. So sometimes in the examination, you might get confusing questions like 20 years from. So where will you calculate those 20 years from? From the date of filing of the application, from the date of grant of the application, from the date of entry into the register that the patent has been granted, or none of the above. So please remember that 20 years is from the date of filing of the application. Also remember, some people might feel that, okay, once 20 years have passed, you can kind of get your patent rights extended. No. Once the period of 20 years has passed, the patent rights cease to exist and the technology forms a part of the state of the art. State of the art means that now anyone can freely use the technology, the patent rights are over. So this 20-year period is not at all extendable. You cannot feel that, okay, my 20 years are ending, so let me do something. And in this case, you have a very important case of Novartis versus Union of India. I'm not sure if you've covered it in section 3D or not, but certain pharma companies, what they try to do is they try to make minor modifications to the patent and file a new patent application, so that whenever their patent is about to expire, they will make minor modifications which are not bringing out any important effect, and they will file a new patent application just to extend the patent rights. So 20 years are expiring, file a new patent application without doing much in your product. And what will happen if that gets granted? Again, you have a period of 20 years, or again, you will have monopoly for the next couple of years or next 20 years. So this is called as evergreening of a patent. And this was discussed in detail in the case of Novartis versus Union of India. This is more of a case of section 3D, but it is also a case wherein companies, they try to evergreen their patents so that they never expire. So please, I don't know if you've covered this case previously, but please note that this is a very important case. And it's important to note that after your 20 years are over, this technology will come in the state of the art. Now, anybody can make, use, sell, import, invention without any hindrance, and patent rights no longer exist. So 20 years from the date of filing of the application and not the date of grant. So please remember, don't get confused that date is to be calculated from which date. The date or the term of 20 years is to be calculated from the date of filing of the application. So that is there. Any question? I'll move forward then. Okay, now we talk about maintenance of patents. Once a patent has been granted, the same needs to be kept in force by paying the requisite renewal fees. Okay, so even if you've become a patent agent, like I'm a patent agent, I have to pay a fees so that my name is kept on the register of patents and I'm still a patent agent. So even though I've cleared my examination and everything, I have to pay either a yearly fees, or let's say I will pay a fees of 5 years in advance to make sure that my name is always there on the register of patent agents. And maintenance of patents is also like that. Once you have a patent, you have to keep it in force by paying the requisite renewal fee. The renewal fee is payable at the expiration of the second year from the date of patent or of any succeeding year, and the same shall be remitted to the patent office before the expiration of the second or the succeeding year. So generally at the expiration of the second year, you have to pay the requisite fee. Now, the renewal of the patent can be done beyond the due date. So they have a due date, which is expiration of the second year. But this is further extendable for a period of 6 months. And this can only be done if you fill up Form 4 and request that extend the period by 6 months. But the period of 6 months is further not extendable. So it is payable at the expiration of second year from the date of the patent. But if you kind of miss it, you can extend the date by filling out Form 4 and you will get further 6 months to kind of pay your fee, but not more than that. You will not get more than, you can only extend it till 6 months and not more than 6 months. So I hope I was clear here.
Madam, I have a question, madam.
Yeah.
Renewal of fees, renewal of patent fees. Can it be paid lump sum for whole 20 years?
Yeah. It can be. It can be paid lump sum.
Okay. Okay. Thank you.
So in case if there is any kind of revision after paying such lump sum fee, we need to pay extra fee if any such direction is there.
Yeah, so fees, I don't think that it's generally revised, but what happens is that if you've paid your 5-year fee in advance, right? And let's say in your 4th year, you see that there has been a revision in fee, but you've already paid your fees for 5 years. So probably you will not be required to pay the additional fees. That's what my understanding is. I'm not really sure, but that's why we kind of intend to pay our fees in one go lump sum, because you never know when the fees get revised. So for example, like I have paid my patent agent fee for like next 5-6 years, because I think that in the next 5-6 years, they are going to increase the fee for anybody who's probably paying it for the first time. But because I already have paid for the 5 years, I will not be required to pay additional fee. So that's what my understanding is. I'm not sure about it, but that's what I think we generally do in practice, that you pay a lump sum so that even if there is any revisions, you don't have to worry about it.
Ma'am, I have one question. If suppose the tenure is likely to be finished, will they remind us, notification us that your patent fees is pending or you have to pay the patent renewal fees?
We are not covered with the entire section right now. I'm covering it. And if suppose you have the same question, then you tell me. I'll first cover the entire section and then we'll talk about this.
Okay.
So moving to the next slide. Now, renewal of patents is covered in Rule 80. Now, what it says is that a patent has cleared the prosecution stage and is moving towards the grant stage. Now, there can be two scenarios. One is a patent has been granted later than 2 years from the date of filing of the application. Generally, this is the case. Generally, within first 2 years, no patent is granted unless it's very, very important that it is being done. But generally, more than that, more likely than not, it takes more than 2 years from the date of filing of the application to for the patent to be granted. So if that is the case, the fee that has become due in the meantime may be paid within a period of 3 months from the date of recording of the patent in the register, right? So the date on which your patent is being recorded in the register, if suppose your patent has been granted later than 2 years from date of filing of the application, so whatever fees has become due, you will pay it within a period of 3 months from the date of recording of the patent in the register. But if a patent is granted before the expiry of 2 years from the date of filing of the application, then the first renewal fees becomes due in respect of third year, right? But the fee may be paid before the expiry of second year. So whatever this time is, it is extendable only by 6 months. So please kind of remember this scenario. I have really not seen a question on Rule 80, but you have to remember that once a patent is moving towards grant stage and you have to ensure that you are renewing your patent. So in that case, you have to see that if it is granted later than 2 years from date of filing or before 2 years from the date of filing. So if it is later, then in that case, whatever fees has become due, you have to pay it within 3 months from the date of recording of patent of the register. Generally, it is this part. If it is granted before the expiry of 2 years, then the first renewal fees will become due in the 3rd year, right? Which is extendable till by 6 months. So kind of remember this. I don't see a very direct question on this, but it's important to know. So let's move forward. Now, sometimes if you do not pay your renewal fee, your patent will get lapsed. So please remember that you have to keep on paying renewal fee to make sure that your patent is there. Your patent is recorded on the patent register. The renewal fee, if suppose, now I have a very simple question here. You are renewing your patent by paying the requisite fee. Now 20 years from date of filing have finished. Now, will you still give the renewal fee to make sure that it's on the patent register? Is it still payable? Like you will
No.
keep on paying the fee?
No,
Yes.
no.
Yes, that's right. I mean, yeah, no is the right answer, because once the period of 20 years expires, you cannot feel that, okay, I will go and pay the renewal fee and keep my patent in force. No, 20 years stuck up, you have to kind of pay your renewal fee till the time your patent is in force, till the time your 20 years have not expired. Once those 20 years have expired, you cannot go and pay the renewal fee and say that, okay, please keep my patent on the patent register. No. So kind of remember it that once 20 years have lapsed, nothing can do to restore. You cannot do anything to keep that patent in force. 20 years expired means your patent has now become state of the art. But during the tenure of the patent, or during the time your patent is in force, you have to pay a requisite fee to the patent office to make sure that it is there on the register of patents. Now, sometimes what happens is that you might not pay the renewal fee. And what will happen? Your patent will cease to have effect because it will be taken off the register, right? So that is what we see, that your patent gets lapsed. So sometimes you will have a lapsed patent because you have not paid the renewal fee. And in real world scenarios, we have seen a lot of times that a lot of companies, they kind of do not pay their renewal fees on time, because of which their granted patents, they lapse and they do not have this, they do not have the effect of a patent in force. So in that case, you will have to file an application for restoration. The application is filed by the patentee, assignee, or his legal representative in Form 15 within 18 months from the date on which patent ceased to have effect. So patent ceases to have effect. For example, I have not paid my renewal fee for 1 year, and from today, my patent ceases to have effect. So within 18 months, which is 1 year, 6 months from today, I have to pay my fees, along with I have to give Form 15, so that my patent, which has been taken off the register, can be restored, right? And the applicant has to state the circumstances which led to the failure of payment of renewal fee. The application must include a statement fully setting out the circumstances that led to the failure to pay the renewal fees. So remember this, that if suppose you're not paying your renewal fee, your patent will be taken off the register and it is considered as a lapsed patent. But if you want to restore it, you can file Form 15 within 18 months from the date on which the patent ceased to have effect. Fill out Form 15 and explain everything, that why was the renewal fee not paid. And you have to explain everything. That's how you will restore a lapsed patent under Section 16. So let's move forward. Now, once you fill out your Form 15 and state the circumstances which led to the lapse of the patent, or why you could not pay the renewal fee, and the controller is satisfied that the failure to pay the renewal fees was unintentional and there has been no undue delay in paying the fees as soon as the fact was discovered, then he will publish this thing in a journal. And any person interested will give a notice of opposition within 2 months from the date of publication in the journal. And the only ground which is available to this person is that the failure to pay the renewal fee was intentional and there has been an undue delay in making the application. Then again, evidence and hearing will be done as per Rule 57 to 63, which we discussed during opposition, and then the controller will give a final decision. If the controller decides to restore the patent, then again he has to publish this in the journal that, okay, this patent had lapsed and now we are restoring that patent. I'll summarize it again. What is happening is that you are not paying your renewal fees and your patent has lapsed. Because your patent has lapsed, it has been taken off the patent register. You discover it, and within 18 months from the date on which the patent ceased to have effect, you fill out Form 15 and say that I want to restore my patent. Now, in that case, you filled out your Form 15, you have to give the statement and you have to explain your circumstances, that why there was a failure to pay the renewal fee. Now, if the controller feels that, okay, you are lying and you intentionally did not pay your fee, then in that case, controller will reject the application. But if he feels that, okay, renewal fee, the failure to pay the renewal fee was unintentional, and as soon as that fact was discovered by the patentee, he has made the application in Form 15, then what will controller do? He will publish the application in the journal. And then any person interested, within the 2 months from the date of publication in the journal that this is the application of Form 15, any person interested will oppose. And he has only one ground of opposition, that is the failure to pay renewal fees was not unintentional. Then evidence and hearing will be done and the controller will give the final decision. If the final decision is in the favor of patentee, then in that case, patent will be restored. I hope I'm clear here. I have one question. Can somebody tell me that who is this any person interested? You can just answer.
The person who is manufacturing or has a direct interest on the product.
Okay, and which section is that?
I beg your pardon?
Which section defines any person interested?
Section 2T.
Section
Sorry?
2T.
Yes, section
2T.
2 defines any person interested, and it's a person who is engaged in the, like summarizing it, the person engaged in the same business or promoting research in the same field. Yeah. So let's move on.
Ma'am, what kind of excuses, I mean, you must have come across such cases, like for restoration of lapse patent, if any applicant is giving reasons to the controller, what kind of excuses are generally seen?
So generally, the excuses which people give, that the failure to pay the renewal fees was not intentional, because let's say I'm a big company, I'm a big pharmaceutical company, and I have a lot of patents, right? And I have, say, one patent agent who is sitting, and probably they did not discover that this patent is being lapsed because they have 100 of patents, they have hundreds of patents to take care of. And they kind of missed this one patent because they did not realize that the renewal fees has become due. And as soon as they realize that, okay, the renewal fees has become due and we have not paid it, I have made the application. So they will probably just show that, we have a big patent portfolio and I missed one patent, and let's say I have 100 patents, and out of which I'm paying for 90 patents, and I have missed out on these 10 patents because I could not fathom the fact that my renewal date is coming close. And as soon as I discovered that, okay, these patents have lapsed, I have made a restoration application. So this is like one excuse. Then it depends on the controller. If the controller feels that, okay, the failure to pay the renewal fee was intentional. Now, why would anybody want to not pay the fees? There can be certain cases wherein people intentionally do not pay the fee. I'll give you an example. Now, for example, I have 2 patents and I'm not paying the renewal fee because I have licensed my patents to a licensee. And if I do not pay the renewal fee, my patent will not be in force, right? My patent will become lapsed. And my, if it's a lapsed patent, then I will probably, my assignment or my, not assignment, but my licensing deed will not have the same effect because my patent has lapsed. Or maybe another example, that I have a patent and I'm not intentionally restoring or I'm not intentionally renewing my patent because I know that I do not want to license this patent, because if suppose the patent, generally, if somebody is taking a license for the patent, they will check that the patent is in force, right? Or if somebody is acquiring my patent, or if somebody wants anything to do with the patent, if a patent portfolio is being acquired, it needs to be very, very sure that all the patents are in force. If your patents are lapsed, then you will not get the same amount. Now, let's say I have to pay the renewal fee. I have licensed my entire patent portfolio, but I do not want the licensee to use my patents or kind of have a benefit from my patents, and I intentionally do not pay the renewal fee so that my licensee is not reaping the benefits. So that is an intentional lapse. That is an intentional way of not paying the fee so that my patent gets lapsed, and the person who is ought to derive benefits from my patents cannot derive it. Right?
In this case, madam, the licensee, the licensor
Yeah.
can raise the objections once it is
Yeah.
published, right?
Yeah.
Because he can do the objection on the ground that it is.
He will come in this part that he's any person interested, and the failure to pay the renewal fees was not unintentional. That means that intentionally they were not paying the renewal fees, so that I cannot derive the benefits, right?
So he can oppose, no?
Yeah, he can. So that's
In
why
which case, in which case, what will be the direction of the controller?
So it depends on the controller. If controller feels that, okay, the failure to pay the renewal fees was intentional, then he can just discard the application and not restore the patent.
Then it becomes open-ended patent,
Then in
right?
that case, your patent is lapsed. I will discuss what happens if the patent gets lapsed and is not on the register. It will be in the next slide. I'll discuss that. So the failure to pay the
Ma'am, can person interested pay the renewal fee? Or just
So I think it only has to be paid by the patentee. So that is the person who is the owner of the
else
patent.
licensee would have done that?
It has to be done by the patentee.
Okay.
Now, when can a patent not be restored? Section 53(4) clearly states that in case the renewal fee has not been paid or the patent term has expired, then the subject matter of the patent is not entitled to any protection. The patent can be restored if the patent ceases to have effect because of non-payment of renewal fee, and the patent can be restored on the register. That means if the patent term has expired or the renewal fee has not been paid, that is, the patent has lapsed, then in that case, the subject matter of the patent is not entitled to any protection. So during that time, if somebody is infringing on my patent, he's not actually infringing on my patent because my patent was not in force. It had lapsed, right? So during the time when the patent renewal fee has not been paid or 20 years have passed from the date of filing, then the subject matter of patent is not entitled to any protection. But if the patent term has expired, you cannot do anything to extend that term. But if the renewal fee has not been paid, you can go and restore as per, making an application in Form 15, paying out the requisite fee, setting out, the process which we just discussed at Form 15, and then controller will discuss if the failure to pay was intentional or unintentional. All this will be done. Any person interested can oppose and everything. And that is when your patent will come back on the register. But if the patent term has expired, nothing can be done. But either of the two cases, if the renewal fee has not been paid or term has expired, subject matter of patent is not entitled to any protection. I'll just move forward. Now, to protect the persons who use the applicant's invention between the date when the patent ceased to have effect and the date of publication of application for restoration, every order for restoration includes the provisions and other conditions as the controller may impose for protection and compensation of these persons. No suit or any other proceeding shall be commenced or prosecuted in respect of infringement of a patent committed in between these dates. So the date on which the patent ceased to have effect, and let's say it is being restored. So if it is being restored and during the time the patent was lapsed, that is, it was not there on the register, and somebody has done infringement, so that is not actually infringement. Why? Because section 53(4) says that the subject matter of patent forms is public. It is not entitled to any protection. So that is why it is important to make sure that your renewal fee is paid and your patent is not lapsed. Because if your patent is lapsed and somebody starts using your invention, then he's not actually infringing your patent, because at that time your patent was not in force, it was lapsed. That's why it is very important for companies to make sure that once the patent is granted, they keep on paying the renewal fee, because if they do not pay the renewal fee, the patent will lapse. And if it lapses and it is not restored, or there is a time period between lapse and final restoration, there is a gap. So during that period, if somebody is infringing, so that will also not be infringement. So I hope I'm making sense. And there was one question with respect to this, and that question is clear. Okay, moving forward. Okay, so this is something which is very, how do I put it? It's not technical, but this is something which you have to know. I've already discussed this, that yes, you can pay the fee at once only in advance. So you can pay the fees in advance. I assume you can. I'll have to check this and again come back. But as per my understanding, you can pay fees in advance. So this is something which I'll just read that out. Why? Because sometimes you might just get one multiple choice question from this and you have to select one. So this is not something which I have to explain. Probably I just have to read this out so that you know that, okay, this is a part and we have to cover it. And sometimes you might just get one question. So I'll just read that out. Patent Office maintains the register of patents in electronic form, which is under the control and management of the controller of patents, and the same is also available on website as e-register. So register of patents is, you can go on IP India website and you can go to e-register and see the granted patents. E-register of patents contains details about the patentee, notifications in respect of assignment, transmission, licenses, amendments, extensions, revocation. So basically e-register will have everything about the patents, like who's the patentee, who's the inventor, everything, assignment deed, if any, if it has been transmitted, if there is any licensee, everything will be recorded. Upon the grant of the patent, the controller shall enter in the register of patents name, address, nationality of the grantee as the patentee, the title of the invention, including the categories to which the invention relates, the date of the patent, the date of grant, together with the address for service of patentee. The fact of payment of renewal fee shall also be entered in the e-register. The register of patents also contains particulars regarding proceedings under the Act before the controller in the court in respect of every patent. I hope this is like just very, very, like it's a go through thing. It is not something to explain, it's just something to read. An application for alteration of name, nationality, address, or address for service is entered in register of patents may be made to controller in respect of any patent. The controller may require proof of alteration as he thinks fit before acting on this request. If controllers allow such a request, entries in e-register are altered accordingly. If a patentee makes a request in writing along with the prescribed fee for entering additional address of service in India, and the controller is satisfied that the request shall be allowed, then the additional address will be entered in e-register. Alexa, stop. Application to IPAB for rectification of register. Section 71 states that an application for rectification of register of patents may be made to IPAB by any person aggrieved by absence or omission from the register of any entry, or by entry made in register without sufficient cause, or by entry wrongly remaining on register, or by any error defect in entry in the register. That means in case there is some wrong entry which has been made in this register of patents, or entry has been missed, or there is an entry which has been done, but it's not clear why that entry has been done, or any error or defect which needs to be corrected, it can be done under section 71. That is, you can make an application for rectification. For example, mostly it happens that your name is entered wrongly. There is a spelling mistake in your name. So section 71 states that in that case, you can make an application for rectification of register of patents to the IPAB by any person who's aggrieved. So you can make that application to IPAB. So this is like a very general thing, but you need to know that, okay, patent office will have a register of patents. That register of patents is e-register. It will have everything about the patentee, if there is any assignment, transmission, licensing, amendments, anything. Controller has to enter the name of the register of the, in the register of the patents, the name, address, nationality of the grantee, address of service. Mostly people choose the lawyer's address as the address of service, and if the renewal fee is paid or not. So every information needs to be entered there. And in case you need a rectification of the register, then under section 71, you have to make a request to IPAB, which is the Intellectual Property Appellate Board. Now, quickly moving forward. Assignment or transfer of rights of a patent. Section 68 states that an assignment of a patent or of a share in a patent, a mortgage, a license, or creation of any other interest shall be valid only if the same were in writing. That means oral assignments are not valid. So you generally have assignment deed of a patent, right? And even if you are filing for a patent, even if it's an employer-employee relationship, employer will ask for an assignment deed. So you always need to have an assignment deed in place in writing if you want to have an interest in patent or you want to assign the patent. Any person who becomes entitled by assignment, transmission, or operation of law to a patent or to a share in patent, or becomes entitled as a mortgagee, licensee, or otherwise to any other interest in patent, may apply in Form 16 to the controller. I'll give you an example. Now, let's say I had a client, and that client was a big company, and they were acquiring a startup. Now, because they were acquiring that startup, they had taken the all intellectual property as well. And in that intellectual property, they had a patent. So initially that patent, when it was filed and granted, or it was in a prosecution stage, the patent belonged to the startup, right? Now, because this big company is acquiring the startup, it is now becoming entitled to all the intellectual property of the startup. So in that case, they are becoming entitled to the patent, right? So they have to apply in Form 16 to the controller, so that an entry is made in the register and it kind of, assignment is done to their name. Or if, even if you're not taking the assignment, you are taking a license, you have to inform the controller in Form 16. If there is any dispute between the parties, the controller may refuse to take action to make an entry in the register until the rights of parties have been determined by the competent court. Now, for example, a person might say that, okay, I am the licensee, and the patentee says that, no, this person is not the licensee because there has been some fraud or there has been some problem in that licensing agreement. So this is a legal dispute which will go to the court. Until the time the court determines it, the controller may say that, okay, I am waiting for the court to give me a direction. And if court decides in the favor of licensee, I will enter it. I will not act till court gives a decision. So it is important to note that assignment should always be in writing, and you have to file Form 16 to the controller in case you become entitled to the share in a patent, right? So I'll just move forward now. Now, surrender of patents, I guess I will cover it because it is kind of really related. So section 63 says that sometimes a patentee may offer to surrender his patent. Now, I have a patent, I want to surrender it. Why? Why would I want to surrender a patent? I have a patent, I've made so much of an effort to get that patent, and now I want to surrender it. Why? Can anybody think of a scenario wherein somebody...
There is likely opposition for the patent granted by means of wrongful obtaining of the patent, in which case the patentee can surrender his patent.
I didn't get that. What? Sorry?
Wrongful obtaining of this patent
okay.
can make the patentee surrender his patent because he is sure of getting defeated in his...
Okay, maybe. And maybe there can be
lack
one
of funds.
Yeah, that is generally the reason that I don't have the money to, keep the patent in force. That patent is taking so much of my money that, okay, I am paying to the patent agent, then I am paying to the patent office to keep it in force. And there are so many, there's so much of money which is going in maintaining that patent. I would rather just surrender it. Or one more scenario I can think of is that, okay, I am having a licensing agreement, and my relationship with my licensee has gone sour, and he's misusing my patent. So let me just surrender it so that there will be no patent, there will be no patent right, and there will be no licensing agreement. So these can be 3-4 scenarios in which a patentee might want to surrender their patent. So what will happen? In this case, the patentee will make an application in Form 14. And once the controller receives the Form 14 and offer to surrender the patent, then he will publish it again, and any person, he will publish the same in official journal, and every other person whose name appears in the register as having an interest in the patent, and they might just come and probably oppose the surrender. So remember, section 63 talks about surrender, which has to be done in Form 14, and this can be done at any time. So there is no timeline that it has to be done in 2 years, 3 years. At any time, this can be done. So let's
Ma'am,
Yeah.
but if somebody doesn't maintain, it will anyways go off, right? It will become lapse and state of art. It will come as under. So what is the need of taking, an extra step by filing Form 14 and surrendering it on its own?
Maybe, it can either lapse, or sometimes people feel that I want to surrender my patent, let's just do it rightfully. So there is no answer to this, because, this is another section, or maybe, they just want to have additional questions for the patent agent examination. That's very valid that, we can always allow it to lapse and not pay the renewal fee. But sometimes, people feel that, okay, let me just surrender it, because let's say I have already paid the renewal fee and my relationship with my licensee has gone sour, and I've already paid the renewal fee for 10 years in advance. Now, what do? I don't want to keep this patent in force, because I've already paid the renewal fee in advance for 10 years. And now I don't want to use this patent because my licensee is misusing my patent. I have given him a licensing agreement, and he's kind of going beyond the licensing agreement and doing things which are not permitted by the agreement. And what do I do now? And he's kind of, making a lot of money and not giving me anything. But I have already paid the renewal fee in advance. So let's go for surrender. So maybe this can be one case.
Ma'am, how is it different from withdrawal of patent then?
It's the same. A withdrawal of patent, no, there can be withdrawal of patent application, wherein your patent application is not granted, and you feel that my FER is very strong, and they are saying that you have no novelty, no obvious, your invention is not novel, it's obvious, it's having no industrial application, and you feel that, okay, this patent is never going to get granted. So that way you withdraw a patent application where it is not yet granted. Surrender of patent happens when a patent has already been granted.
Okay, got it.
So now let's move forward. Next slide. Now, what is the procedure for surrender? Now, patentee will file Form 14 stating his offer to surrender the patent. Controller will publish the offer in the official journal. Again, any person interested will oppose. Then again, statement, counter statement, evidence, hearing, everything will be done by the controller. And then the final decision will come. If the final decision is in favor of the patentee, then the fact will be published in the official journal, because you are altering the status quo. So always remember this thing, that if you are altering the status quo, for example, a patent is existing and you are taking it off the register, or a patent is not existing, it has lapsed, and you are bringing it on the register, you have to give a notice in the official journal. So whenever you are altering a status quo, always the fact will be published in the official journal. And generally, if it affects more people, then always in the procedural law, there always will be an option to oppose, because here somebody might say that he's surrendering the patent and it is affecting me. For example, I am the licensee and I am making money out of the licensing agreement of this patent, and now my patentee surrendering the patent is going to hamper me. So I might oppose the patent, right? So that's why always remember that any status quo is being altered, the fact will be published in official journal. And if there is any offer which is being made and it might affect some other party, so the law will always say that the other party should have an option to intervene by opposition or by joining or whatever. So these are the two basics which you have to remember for this law. So I'll just move forward.
What is the timeline, madam?
Sorry?
What is the timeline?
For what?
Timeline for this, the previous slide,
Yeah. So I don't think there is any timeline which is mentioned. Surrender of patent can be done at any time while the patent is in force. And I think it should be 2 or 3 months for the opposition to be given by any person interested. I'll check and get back to you. I guess it should be 2 or 3 months if I have not mentioned it in the slide. Let me just check. I will just check and get back if there is any timeline on filing the opposition. I'll get back on that, but surrendering can be done at any time. So these are certain key takeaways.
Ma'am, I think the same rules are being followed, rule 57 to 63. So the same timelines must be there.
57 to 63 is for taking the evidence and hearing and all. So that is 57 to 63. 57 to 63 is important because those are the rules every time will be followed for taking evidence and for hearing. But there might be a timeline for surrender of patent. Let me just check. The patent can offer to surrender. Yeah, it is 3 months. So the notice of opposition must be given to the controller within a period of 3 months from the date of publication of notice to surrender the patent. So 3 months is the time period to oppose it. I'll just write it here. Opposition to surrender patent filed within 3 months from the date of publication of notice to surrender the patent. I'll just type it out and yeah. So these are certain key takeaways. The rights of a patentee are listed in 48. Exception is in 47, 107 and 107A. All co-owners have equal share in patent unless there is an agreement to the contrary. The term of a patent is 20 years from the date of filing of the application. Once this 20 years expire, there can be no extension of the application. A patent needs to be maintained by paying the requisite renewal fee. If you do not pay your renewal fee, then what will happen? The patent will be taken off register and the subject matter of the patent becomes public. The patent rights can be assigned or transferred, and the patent can also be surrendered. So these are the major points. So I'll just quickly take up some questions. So let's move to the next slide. I want someone to answer this question. A patent, this was in 2018 patent agent examination. A patent awarded by Patent Office of India is valid in
Indian territory.
Indian territory.
Yes. So a patent which is granted in India will have effect. Yes, it will have effect only in the Indian territory. For other countries, it will not give you rights. If you could all just go on mute now. For other countries, it will not give you the same patent rights unless a patent is granted in that country. So if it is not granted in US, you will not have a patent right in US. But because you have a patent in India, it will become a prior art for you, but you will not have a patent right. So your patent will not be valid in US, it can become a prior art. But if a patent is given in India, it will have effect only in India. So let's move to the next question. When a patent completes its full term of 20 years within the provision of the Act, then what happens to it?
D.
D. You cannot renew after the term has expired. Next question. A seized patent due to non-payment of renewal fee may be restored by filing an application of restoration with the prescribed fee as per the Patent Act. So when can you file it?
B.
B.
B within 18 months.
Within 18 months from the date on which the patent ceased to have effect. Yes. Let's move. 3 applicants applied for a patent in India and the patent is granted to them. And now there is a doubt amongst them regarding their patent rights. As a patent agent, what will be your clarification?
A.
So section 50, everybody has an equal undivided share in the patent until unless there is an agreement to the contrary. So,
A.
A.
yes. So next, move forward. You have to state true or false. As per the provision of Patent Act, a patentee may at any time after the grant offer to surrender his patent. As per the provisions of the Patent Act 1970, a patentee may offer to surrender his patent only after 3 years from the date of grant.
A is
So
true.
A is true.
Yes. So
A.
A is true. Yeah. So A is true and B is false. Let's move forward. Now here you have multiple answers correct. So there are more than one correct answer. Applicant A has been granted a patent. As per the Patent Act, the exclusive rights would be conferred upon A to prevent third parties who do not have his consent from
A, B, C.
ABC.
yes, making, using, selling, importing. Those were the 4 acts. So because multiple are correct, ABC. Please always remember that in patent agent examination, there are in objective type, there are, I think, 3 sections. One is going to be one answer correct. One is going to be multiple answers correct, and one is going to be true and false. So in multiple answers correct, if your answer is ABC and you only mark AB, you will not get marks. You have to mark ABC. Or let's say if you mark ABCD, then also you will not get marks. So if ABC is the answer, you have to mark A, B, C. If you miss C, you will not get marks. Or if you miss 1, you will not get marks. So remember that. Let's move forward. Now, ground for opposition to the restoration of a patent can be
C.
Failure to pay the renewal fees was intentional.
there is only one ground which is available for opposition to restoration. So do not confuse opposition to restoration with section 25, which is otherwise a general case of opposition. When we are talking about opposing a restoration, then there is only one ground, which is the failure to pay the renewal fee was intentional. Right. So if that is the case, that the failure to pay the renewal fee was intentional, then that is the ground for opposition to restoration of a patent. And do not confuse it with section 25. Let's move forward. The time period for paying a renewal fee without extension as per section 142(4) after the recordal of patent is, there's a certain time period. Yes, 6 months. So please go back and read section 142. I'll also probably read that out. What was section 142? Section 142 talks about fees. Section 142 says that there shall be paid in respect of grant of patents and application therefore, and in respect of other matters, respect of doing any act by the shall not do that act until the fees has been paid. Where a fee is payable in respect of filing a document, the fee has to be paid along with the document or within the prescribed time, and the document shall deemed to not have been filed if the fee has not been paid. And 142(4) says that a principal patent is granted later than 2 years from the date of filing of the application. The fee which has become due in the meantime may be paid within a period of 3 months from the date of recording of the patent in the register, or within the extended period not later than 9 months from date of recording. Okay. So 3 months from the date of recording of patent of the register, and extendable not later than 9 months from the date of recording. So that means the total time period should not exceed 9 months. That means 3 plus 6. Okay, I'll just type that out in the chat box. This is section 142, which talks about fees. Again, I'll summarize it. It says It says that you have to pay fees if it is required. If you will not pay the fee and the controller is required to do something, he will not do it. If you have filed a document and with the document you have to pay a fees and you have not paid that fees, that means your document has not been filed. And if a renewal fee is there's a time period for paying the renewal fee, which is 3 months, and it can be extendable till total period of 9 months, which is 3 plus 6, without extension, as per section 142(4), after the recordal of patents is 3 months. So I'll just type that out and it. Yeah. So where a principal patent is granted later than 2 years from the date of filing of the application, the fee which has become due in the meantime will be paid within a term of 3 months from the date of recording of patent. So B is the answer, and not later than 9 months. Extendable for a further period of 6 months. So 3 plus 6 and not extending. Overall, it should not extend 9 months. So the answer is 3. Without extension, it's 3. With extension, it total becomes 9. So further extendable or for 6 months. So see, again, these 3 dates are like really confusing. 6 months, 3 months, 9 months. So 3 months is extendable. And then further 6 months, that means total 9 months. So that is the point. So let's move further. As per the Indian Patent Act, patentee means nobody wants to attend. Yes, and which section is that? Which section is that?
2P.
2P.
Yes, so 2P is the section.
2-1P.
Yeah, 2-1P. Right. So let's move forward. Next question. Again, multiple answers correct. Patent of Mr. X was seized due to non-payment of renewal fee. His rival, Mr. Y, comes to know that Mr. X has applied for restoration. On which grounds Mr. Y can oppose the application for restoration?
C.
C. No.
B.
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 B. Sorry. B and E.
Intention.
D and D.
B and D.
Yeah, B and D. So
B and
C. Yeah, right. Next slide. So the grant of a patent, this is a subjective type. The grant of a patent is based on certain conditions as stipulated in section 47. So you have to explain section 47 here, direct question. And the second question, if you can just tell me what section is going to apply here in the second question. Just
49.
read that out.
49. 49.
Section 49.
Only have to explain 49. So I guess we are done here. No, we have one more. Right. One client A has come to your office seeking advice regarding assignment for a solar cooktop that B has already patented. So what will you tell him? First things first, that the assignment should be in writing, right? Second, he has to file Form 14, right? And what else? Is there anything else which comes to your mind?
Fees.
Sorry?
Fees.
Sorry?
He can in-license the patent from the
Yes.
client.
So yeah, he has to ensure that he's paying the requisite fee and making sure that the patent is not lapsed. Right? So these are 2-3 things which, so this is a very subjective answer. A lot of things can come to mind of a lot of people, but what I think of is that first you have to make sure that you tell them that the assignment has to be in writing. Second, you have to tell them that once you do your assignment, you have to make sure that you file Form 14 and inform the patent office or the controller about it. Then third thing you need to know is that the patent should not be lapsed, because otherwise your assignment will not make any sense. So make sure that, you know, your patent for which you are taking the assignment, it's not getting lapsed, or it's not lapsed and it's on the register. There is no failure to pay the renewal fee. Anything else which comes to anybody else's mind? Because this is what is coming to my mind here.
And one more thing, madam, this assignment should not be given to somebody else also without this man's
Assignment
knowledge.
is exclusive. In licensing, you have multiple licensees. So a patentee can have multiple licensees, but assignment is exclusive. You cannot have multiple assignees. Assignee can only be one. Assignment is always exclusive, as per my understanding.
Then it becomes an exclusive assignment, no?
Yeah, assignment is always exclusive. So either it is assignment or it is licensing. And in licensing, there can be exclusive licensing or non-exclusive licensing. But there is nothing which is called as exclusive assignment, because assignment means complete assignment and there cannot be multiple assignees for it. So I hope I'm clear here.
Yeah, madam. Okay.
So that is what we had for today. So I was supposed to cover this. I thought that it's going to take 4 hours because I thought the number of slides is like really long. So it might take 4 hours for me to complete it. But I guess we will not have tomorrow's lecture because whatever was to be covered tomorrow, I've already covered it today. And also for the next week, I guess we will not cover surrender because we've already covered surrender here. So next week is only going to be revocation. Okay. So I will discuss with IACRD if there's going to be a session tomorrow, but it was only a carry forward of today's session. And because we've covered everything today, we might not need a session tomorrow.
Ma'am, have you covered section 52? I guess
Section 52.
grant a patent to true and first inventor where it has been obtained by another in fraud of.
In fraud of him, no, I have not covered section 52. So this was something which we kind of covered in section 26. So that's why I have not covered in section 52. So
Okay.
there was a similar section, which was section 26, where it was a wrongful obtainment. And probably I will cover this when I talk about revocation, because it says that where a patent has been revoked under section 64 on the grounds. So this will probably form a part of section of the revocation part when we will cover the revocation part. So I've not covered it today.
Or maybe section 26 is for not granted patent. This is for
Yeah,
granted.
section 26 was during opposition
Opposition.
proceedings.
Right.
Yeah. So section 26 is during opposition proceedings. This is during revocation. So it starts with the fact that the patent has been revoked under section 64. So we covered with section 64. So this was only 43 to 53 that we are covering, and I have not covered 52, but instead of 52, I have covered restoration of lapsed patents, which is section 60, 61, 62. And I've also covered 63, which is surrender of patents. So I'll just type out. I've covered 43 to 51 and then 53. 43 to 51, then 53. Then I have covered 60 to 63. I have covered. Also, I have covered section 142. Because 52, I'll probably cover it with revocation. Because we have 64, 65, 66, and then I'll cover it with that.
Just one query I have. Does the multiple assignment is possible? Because while searching, I have seen certain patent wherein there were multiple assignees.
So there will not be multiple assignees, but there can be joint assignees, like joint assignees as in, for example, there are 2 or more people who have kind of contributed to the patent. Like there has been IIT Madras and then there is IIT Delhi who have been contributed to the patent, right? So both of them become joint applicants. But I'm talking about in case I already have a patent and I want to give my entire rights. So I cannot be like that I am giving my entire patent to A and B. I can only give my entire patent to either A or B. Assignment can only be like, I cannot have, I'm kind of comparing it with licensing. So in licensing, what I can do is that I can have multiple licensees and I can take licensing fee from A, B, C, D, whatever licensees I have. But if I'm having assignment, that means I'm giving complete rights to my assignee, and that assignee can do whatever it has with patent. So they can be joint applicants. For example, there are two companies which are contributing, but if it comes to me and I have assigned my patent, I can only assign it once. I cannot assign it multiple times.
Sure, that is clear. Only one more question, just in addition to that. Can we also know, is there any possibility how many licenses have obtained the patent from the assigned?
So if it's an exclusive license basically means that I'm giving license to only one person and nobody else has that license. So for example, say Pfizer gives an exclusive license to Bharat Biotech to make the COVID-19 vaccine, let's say in India. And that's an exclusive license and nobody else is having that license. But it's a license. It's not an assignment. But if it is making a non-exclusive license, then there can be multiple licensees. And let's say there are 10 licensees of Pfizer in India. All this information will be entered in the patent register, which we talked about, register of patents, that everything has to be entered there. So all the information will go there.
Ma'am, I don't know if this is related, but if we are talking about register of patent, in case if I am filing one provisional application, and after that, within 12 months, I'm filing a complete application. And while filing provisional application, applicant, there was only one applicant. And while filing complete specification, if one more applicant is added, then how to proceed with that? I don't know. I mean,
so let me just tell you, a provisional is just there to preserve your priority date, right? It is kind of just giving you a window of 12 months to file your complete. Now, once you're filing your complete, you will have to file your Form 1, Form 2, Form 3, Form 5, which talks about all these things. So which will kind of include everything. So Form 2 is your form of complete specification. Form 1 will have all the details. Form 5 will be your declaration of inventorship. All these things will go, right? So if you're filing complete, you can file all the documents along with it, because the only purpose your provisional is serving is just to give you a window of 12 months. It is not giving you any right, and it is not telling you that, okay, now you can't do this. So while filing complete, you can file all the documents that you want to. If there is a change in assignee or there have been more inventors, everything can be filed at the time of complete.
Okay. Thank you.
Just one extended question onto that. So if we try to invalidate a patent from an assignee or the patentee, and then he has licensed it out to 3 other people. So will all four of them will be liable to pay me the if it is proved, if all 4 of them will be liable to pay me the reimbursements, or will it be only one?
You'll have to repeat your question.
Assume there is one patentee who obtained a patent in India, and he has out licensed it to 3 more people. So now there are 4 people who are using that patent, and I kind of invalidated that patent. So will only invalidated that patent using my earlier patent. So will only the patentee has to pay me the liabilities, or will the licenses also will come into effect?
So this is something which we will cover in infringement. Generally, if it's an exclusive licensee, they kind of join the suit for infringement. Like you're probably trying to say that there is a patentee who has a patent, and you realize that, okay, this patent is infringing on my patent, and you file a infringement case, right? That's what your understanding is.
Yes, I'm good.
So this we will cover during infringement proceedings, and generally the defendant in this case will be the patentee who is infringing on your patent. But in certain cases, the exclusive licensee, not the non-exclusive licensee, but the exclusive licensee can join in the suit for infringement. So
maybe the terms and condition of whatever the license is, that might be.
That is also there, but I am also talking about from the perspective of the act. So what the act says. So this, it would also depend on the on your agreement. So mostly in the licensing agreements, you have a clause which says that any renewal fee or suit for defense or anything, it is the cost of the patentee. So mostly the licensees, they try to safeguard themselves by including this clause that all suits for infringements will be handled by the patentee. So mostly the licensees have this kind of an agreement wherein they don't want to bear the cost of any infringement proceedings. But in certain cases, they can join as a defendant. But generally,
Thank you for that.
They will have that. So I guess we are done. So thank you so much. I guess we'll meet next week. Thank you.
Thanks, ma'am.
Thank you. Bye.
Thank you, ma'am.